The Commission adopted today two antitrust decisions addressed to Motorola Mobility and Samsung. These two decisions relate to the enforcement by these companies of patents which are essential to two telecom standards, the second and the third generation standards, commonly known as GSM for the second generation and 3G for the third one. Today's decisions will provide additional guidance to the industry on the interpretation of our competition rules regarding the enforcement of a particular class of patents, the so-called standard essential patents, or SEPs. These patents are technically essential to implement a specific standard. In practical terms, it is not possible to manufacture products that comply with the standard, such as mobile phone or tablets, without using such patents. More than 1,300 patents have been declared essential to the second generation, or GSM standard, and nearly 3,000 patents have been declared essential to the third generation UMTS standard, developed by the standard setting organization of the sector, ETSI. And these standards need to be implemented in all smartphones and tablets sold in Europe. Our two decisions today clarify how EU competition rules apply in such a situation. First, our decisions affirm that recourse to injunctions is generally a legitimate remedy for patent infringements. Second, our decisions clarify that the seeking of injunctions may be abusive when two conditions are met. First, when a SEP holder has given a commitment to license on FRAND terms during a standard setting, and second, that the potential licensee is willing to enter into a license of FRAND terms. The Commission has concluded that Motorola abused its dominant position as a SEP holder by seeking and enforcing an injunction against Apple in Germany. Motorola sought this injunction on the basis of one of its second-generation patents. It's true that Motorola had committed to license the SEP to third parties on FRAND terms, and Apple had agreed with Motorola that in case of a dispute, the German courts would set the applicable FRAND rate and Apple would pay royalties accordingly. However, and this is the problem under which we based our decision, Motorola persisted in using the threat of an injunction to force Apple into a settlement agreement with very restrictive conditions. Samsung has sought injunctions against Apple in various EU member states on the basis of standard essential patents for the third generation standard. During our investigation, Samsung offered commitments that were market tested and then amended. The Commission had decided today to make the final version of these commitments legally binding through an Article 9 decision. Samsung commits not to seek injunctions for 5 years in Europe on the basis of standard essential patents for smartphones and tablets against any potential licensee who agrees to accept a specific licensing framework.